it will be a much worse situation than the NJAC.
Particular manner.
No, we are not saying that make a law. I'm not asking for a law to be made, my lord. So therefore, my lord, this would be, in my respectful submission, a neutral body where the main stakeholders do not play any significant role. And that will ensure. The argument, Lord, the main issue in these cases, the appointment of the members of the Election Commission.
That's right.
Actually, let me proceed along the note that I have just handed over.
Yeah, I'll pick up from.
As your lordship is aware that Election Commission is a body charged with conducting free and fair elections, which are certainly essential for democracy, which is a basic feature of the Constitution. There is no dispute about it. Election Commission has a number of very, very important powers, such as we have mentioned, my lord, what are the powers that the Election Commission enjoys. It has the power to register political parties at page 4 of this note. It has the power to recognize political parties and allot symbols. It has the power to take decisions regarding splintered or rival groups arising within already recognized parties. This is one of the matters regarding Shiv Sena, which is currently before this court also. It has also the power to suspend or withdraw recognition of recognized political parties for failure to observe model code of conduct. It has also the power to enforce model code of conduct, in banning candidates from campaigning during elections, removing star campaigners from elections, etc. So it has complete and total powers regarding conduct of elections in this country. It has from Shamsher Singh onwards, my lord, large number of decisions. Now the question is, can such a body, the article in the Constitution which deals with the appointment is 324(2). It says, appointment of the Chief Election Commissioner and Election Commissioners shall be made by the President, subject to any law made by Parliament. It says Election Commission shall consist of the Chief Election Commission and such other election commissioners, if any, as the President may from time to time fix, and the appointment of the CEC and other election commissioners shall, subject to the provisions of any law made on this behalf by Parliament, be made by the President. So unfortunately, my lord, when the Constituent Assembly debates took place, Dr. Ambedkar said that, look, we expect Parliament to make a law to provide for some kind of independent selection of these election commissioners. But unfortunately, my lord, we are now 70 years down the line, 71 years since the Constitution was made, or 72 years since the Constitution was made. No law has been made by Parliament till today to regulate the appointment of the election commissioners, and it continues to remain in the hands of the government. Now, Lord, the factual situation is that till the time that Mr. Session was appointed election commissioner, the election commission's independence was seriously in question. After Mr. Session, there was a long period where, for one reason or another, Mr. Session set the tone and the election commission behaved fairly independently for many years thereafter. But unfortunately, today it is no longer the case for the last several years. And these doubts about the independence of the election commission have been recognized by a citizens' commission, which was headed by Justice Lokur, who said that today the independence of the election commission is seriously in question. Now, it was thought initially that maybe perhaps the mere fact that the election commission, that the functioning of the election commission is not controlled by the government, and that the election commissioners cannot be removed by the government except by following a fairly stringent procedure. In fact, my lord, the removal is through
Impeachment
impeachment.
of the Supreme Court judge.
Judges.
Yes, just like Supreme Court judge. But unfortunately, my lord, that by itself is not enough to ensure that the election commission functions independently. That is just functional independence. True that the election commission does enjoy functional independence in that sense. But if the appointment, and that was recognized in the judge's case and several judgments in the cases relating to appointment of judges by this court, starting with Scora, thereafter with the NJAC commission, that just functional independence by way of ensuring that the removal cannot be made by the government or government does not enjoy disciplinary powers is not enough to secure the independence of the judiciary. If the appointment remains completely in the hands of the government, then that itself,
Mr. Bhushan,
yes, please.
we are not examining the ground realities
Yes.
or the individual's perception.
Yes, we are not.
We are examining the procedure being followed
Yes.
in making an appointment, whether it is in conformity with the constitutional mandate or not.
Right.
And if not, according to you, what are your suggestions
Yes.
to make the better system transparent and the people's faith,
Yes.
which is the
Your Lordship is right. We are not,
predominant?
that's why
We
we
want to know from you what is the mechanism as on today in implementing 324.2 and what is the mechanism which you suggest to us
so, my
in
Lord,
addition to it.
so I would have come to this question. Your Lordship has put it right in the beginning. So let me state it right up front. So there are 5 commissions which have gone appointed by the government, which have gone into this issue as to what should be the method of selecting and appointing election commissioners. The last one being the Law Commission in 2015. So the Law Commission recommended a procedure similar to the procedure currently in place for appointment of the CBI director. That is, Prime Minister, a committee consisting of Prime Minister, Leader of Opposition, and the Chief Justice of India. This is in my respectful submission, my Lord, that's my alternative suggestion, though in my note I have not written that. Because one of the things which agitated this court in the judges appointment case, especially in the NJAC case, where NJAC was declared to be unconstitutional and violative of the basic structure, was if you have a system where the government also plays a role and the judiciary also plays a role in the selection of judges, that means they jointly decide the selection of judges. Then they said that there is a possibility and a fear of give and take happening between the government and the judiciary, which is also not good for the independence of the judiciary. So they said that government should be totally removed. The only power that the government should have is to send the name back once. Thereafter, if it is unanimously reiterated by the collegium, then the government has to appoint that judge. Because there should not be any give and take between the government and the judiciary regarding appointment of judges. Now, and the basis for that was that the government is the main litigant in the judiciary or major litigant in the judiciary. Government has a stake in so many cases, especially cases involving protection of fundamental rights of citizens. And therefore, being one of the main stakeholders, it should not play any significant role or any role in the selection of judges who are going to be deciding these disputes which involve the government as a major party. Same thing I would suggest, my lord, so far as election commission is concerned. Of course, my default suggestion would be to follow what the Law Commission has said. That is, Prime Minister, Leader of Opposition, Chief Justice. But my first suggestion in my respectful submission is both the Prime Minister and the leader of some opposition being heading political parties which are key players in the election process, ideally should not have a say in the selection of election commissioners, because election commission is the body which is going to decide not only disputes between the government and the opposition, etc., but is going to play such a critical role where the interests of the ruling party and the opposition are directly involved. Therefore, in my respectful submission, my lord, the selection should be by a body which is totally neutral. So such a body could be the Collegium of the Supreme Court. This is one possibility. The other possibility is that you say Chief Justice of India, you can add the present Chief Election Commissioner, because outgoing chief or the existing, if a selection of a member of the election commission, then the present chief election commissioner. You can add perhaps chairman of Human Rights Commission or somebody like that. You can add perhaps, I am not saying, my lord, what the situation is today. I am saying that ideally it should be, the selection should be in the hands of a body which is totally neutral. And though today, because the election commission is being appointed by the government, today the comptroller and auditor general is also being appointed by the government alone. Yet both election commission and CAG at least have functional independence. That means they cannot be removed by the government at their own sweet will. So in my respectful submission, there are these two kinds of bodies which will be totally neutral. One is the Collegium of the Supreme Court, which is the same collegium which selects judges. No, because it has to be a neutral body. What I am respectfully submitting is, my lord, the recommendations.
Keep one thing in mind.
Yes, sir.
And we can share our experience.
Yes, yes.
Wherever there is a human discretion
Yes.
element is there, discretion element. By and large, our experience also shows.
Yeah.
Now, the only thing which we visualize from you is how this human element discretion
Yes.
available can be minimized. That only reflects your transparency. Because the discretion exercise, you have to keep the faith over the people who are manning. Ultimately, like we people in our judiciary, we take action against our judicial officers, and the same very judges who are party to those minutes and who have reported their signatory to take action against him, tomorrow sit in the judicial side and set aside the orders. Transparency is there, but still human element is
So
there.
your lordship is right that.
And once we come out with the doctrine of necessity, somewhere down the line we have to show our trust over the persons who are manning the posts, and this discretion has to be exercised.
So, my lord, here there is no doctrine of necessity in the present system, because the selection is totally by the government, only by the government. Nobody else plays any role, and the government is clearly a partisan player in the matter, in all the matters which the election commission decides, because the government is heading a political party which is a key player in the conduct of contesting elections. So therefore, on the principles laid down in the judges' appointment cases, as well as there have been several cases, my lord, where your lordship have directed, even for CBI director, it was this court's direction which eventually led to that in Vineet Narayan.
This suggestion or submission is meant for the time during which there is no law made by parliament, or you want to assume
Higher
court
status. I want, Lord, your lordship to lay down, because it should not be that tomorrow the parliament makes a law. Suppose today the court directs that the selection of the election commission should be whatever. Suppose the court says, all right, Prime Minister, as the Law Commission has recommended, Prime Minister, Leader of Opposition, Chief Justice. And thereafter the government brings a law saying that no, it will be by the government. It will be a much worse situation than the NJAC Act. In the NJAC Act, the only role of the government was that in the selection committee there was a law minister and there were two other people, jurists who would be selected between the government and the Chief Justice, etc. And that the secretariat would be housed in the law ministry.
But judges' appointment is the provision in the constitution, there was a consultation which we have interpreted over a period of time.
Yes.
Here there is a specific mandate of the constitution that parliament by law can make this
Yes, Lord.
appointment. Now,
That is true.
how do you want us to confer on ourselves a jurisdiction to read down
What I
that
would-
part of Article 24(2)?
Yes, Lord. What
In
I
that regard, one more.
yes.
See, 324(2), it says for appointment of the chief election commissioner and other election commissioners shall,
Yes.
subject to the provision of any law made in that behalf by the parliament.
Yes.
And now in the unamended petition, you sought for issuance of a mandates.
Yes.
Now, of course, you are seeking issuance of any appropriate direction. To what extent you are saying that this court can issue a specific direction to make a law in a particular manner?
No, we are not saying that make a law. We are.
In the light of the directions, the prayer, that is what
I
we
am
are.
not seeking that.
Of course, 324(2), it says
I am not asking for a law to be made, my lord.
prayer. That is why.
Maybe, my lord, that
Yes.
may have been written.
Because the prayer, see, the amended prayer, of course, mandamus was the, originally it was sought for. Now, in the amended petition, you sought for another prayer, issue an appropriate order or direction
Yes.
to respond to implement an independent and transparent system.
So that's why, my lord, the original writ petition was not filed by me. When the petitioner came to me, I told him that you can't seek a direction to Parliament to make a law. So therefore, my lord, I sought permission to amend the petition. Permission
And
was
instead
granted.
of that, now you are using the expression implement.
No, we are saying respondents to issue a writ, order or direction to the respondents to implement an independent and transparent system for appointment of members on the election commission on the lines recommended by these various commissions. 4, 5 commissions, 5 commissions which went into it. But I am now today, my lord, in my oral submissions going one step further. I am saying that these commissions recommended a selection committee consisting broadly Prime Minister, Leader of Opposition, all of them say. In addition, there is some difference. Some of them say Chief Justice, some of them say
That's
some
what speaks.
Speaker, etc. I am going one step further in line with the NJAC judgment. The NJAC judgment says that, look, this system where the main stakeholders also play a role in selection of judges, though the dominant people may be independent, but if the main stakeholders also play a role, then that will be amenable to give and take, which is not good for the independence of the judiciary. I am saying the same thing with regard to the Election Commission. Today, my lord, Election Commission, the main political parties are the main stakeholders before the Election Commission. They are the main stakeholders. And therefore, in my respectful submission, the system should be selection by a totally neutral body. Now, what that neutral body could be, I have said. One option is the Collegium of the Supreme Court, just as they select judges. The second option is that you can have 3 senior judges of the Supreme Court along with let's say the existing chief election commissioner, the chairman of NHRC or the CAG. I am mentioning these authorities because at least they enjoy functional independence. Today, tomorrow, my lord, after your lordship's direction in this case, assuming that we succeed, the election commissioners will also enjoy independence by way of selection. And once that happens, then of course, my lord, the chief election commissioner can certainly be in the selection committee or the outgoing chief election commissioner, if this selection is of the chief election commissioner, certainly be on the. So therefore, my lord, this would be, in my respectful submission, a neutral body where the main stakeholders do not play any significant role. And that will ensure. The argument is this, my lord.